Well, hello everyone, and welcome back to part 2 of our Chapter 10 lecture covering the exclusionary rule and entrapment. So again, this is part 2, and if you recall, we left off, we spoke a little bit about invoking the exclusionary rule. How do you do that? And then we talked a lot about standing, and I hope I was able to kind of clear everything up as it relates to standing. So now we want to look at some exceptions. Are there exceptions to the exclusionary rule? So we have seen that in the Mapp versus Ohio Supreme Court case. Here the Supreme Court held that the exclusionary rule was a constitutional rule that was intended to deter the police and protect the integrity of courts. And the U.S. Supreme Court in 1974 also modified this holding and basically said that the exclusionary rule is a judge-made remedy that is designed to deter unreasonable search and seizure. And there were a number of cases that followed in which the Supreme Court began to recognize, or did recognize, some exceptions to the exclusionary rule. Now, these exceptions are based on a determination in each instance that the modest amount of additional deterrence to be gained from excluding the evidence from trial is outweighed by the cost to society of excluding the evidence from trial. So as we discuss this in a little bit more detail, pay particular attention to the Supreme Court's employment, if you will, or introducing the balance test, and and how that is brought about. So with that said, let's go ahead and let's just jump into some of the exceptions. So there are several, and I have 6 listed here. The first being collateral proceeding, the second being attenuation, and that means reduction or reduces. The next one being good faith, then independent source, inevitable discovery, and then finally impeachment. So we'll just kind of go over these individually because I think it's good that we have an understanding that there are some exceptions to it. So let's talk first about collateral proceeding. So the collateral proceeding exemption or exception permits the use of unlawfully seized evidence in proceedings that are typically not part of that formal trial process. Those are the ones that are kind of like, what's a good way to put it? Off to the side or really loosely regulated compared to the trial. And this would include things like bail hearings or preliminary hearings or even sentencing hearings. And it can also be used at parole and immigration hearings. So what is the explanation for this particular exception? Well, in most of these collateral proceedings, there is an interest in full presentation of the facts. The application of the exclusionary rule would deny judges evidence that might prove useful in determining whether to charge a defendant with a criminal offense in setting bail or in sentencing a defendant. And balancing citizen protection against this is the fact that the Supreme Court has concluded that excluding the fruits of an unlawful search from these proceedings would have little additional impact in deterring police violations of the Fourth Amendment. So the police already are deterred by the prospect that unlawfully seized evidence will not be available to establish a defendant's guilt at trial, and little additional deterrence will be achieved by excluding evidence from these smaller collateral type situations or proceedings. So that's collateral proceeding. The next would be what they call attenuation. And that's, we talked a little bit about kind of, well, I'll go ahead and just go through it. So attenuation, in the typical case, there is a direct causal connection between unreasonable search and seizure, or unreasonable search and the seizure of the evidence, meaning that the evidence is the product of that unlawful search. In other instances, however, that connection is basically, between the search and seizure of the evidence is attenuated, or it's weak. It's really not that strong. So the U.S. Supreme Court has basically held that the exclusionary in these cases wouldn't apply. A weak connection between the unlawful search and the seizure of evidence also is referred to as dissipating the taint or purging the taint. There's a couple of different legal forms, kind of comes into play. So let's look at an example to maybe help clear this up in a case called United States versus Boone. And here an officer stops a vehicle with 2 occupants, and the officer searches the vehicle and finds drugs. And as the officer turns away, the suspects flee in the car pursued by the officer. And during the chase, the suspects throw the drugs out of the window. So, I mean, now think about that. Would there be any, can you see the separation there, I guess? Again, the officers followed these defendants, and facing imminent apprehension, they threw those drugs out the window. So the discarded narcotics were subsequently seized by the police. So should the drugs be excluded as the product of the officer's unreasonable search? I mean, think about that. Is there really a connection there or no? Kind of an interesting thing. So let's look at another one. The next one, so that would be attenuation. The next would be good faith. In 1976, Supreme Court Justice Byron White, in dissenting in the Stone versus Powell case, argued that the exclusionary rule should not be applied where evidence is unlawfully seized by an officer acting in the good faith belief that their conduct complies with the Fourth Amendment and the officer has reasonable grounds for their belief. So this is kind of an interesting one. This whole good faith. And there are 5 circumstances that the courts will look at that. When we talk about the good faith exception, one would be the reliance on a warrant. So if there was something tweaked in the warrant, but you went to the third-party judge to get the warrant and you had good faith that it was a good warrant, that would probably fly. The next one, reliance on assurance by a judge that a warrant meets the Fourth Amendment standards. Again, that third party. Reliance on legislation, meaning that there's a law in effect. Reliance on the data entered into a computer system by a court employee. So let's say that somebody enters data, but it's incorrect, saying that this person has a warrant, but they really don't because it was a clerical error. But you detain the individual because it's his information and you verified his identity. The information is just entered on this person incorrectly. and when you detain the person, you search them and you find a bunch of drugs. Should that be thrown out, or was there good faith that the officer was operating on reliance that the data was good? Does that make sense? And that one's actually pretty, I think, easy to kind of understand. And then finally, reliance on apparent authority of a third party. Maybe somebody that says that they're in charge of something and give you consent to, let's say, search, but it turns out maybe they were not in charge, but you really believed that they were. So this is part of the good faith exception. And they actually have some text written on the exclusionary rule and the good faith exception. Okay, another one would be independent source. And we have seen that evidence that is directly obtained as a result of an unconstitutional search is excluded from evidence at trial. This particular exception or doctrine, if you will, provides that evidence that is unlawfully seized nevertheless is admissible where the police are able to show or demonstrate that the evidence was also obtained through independent and lawful means. So maybe somebody else found the same information, and hopefully that kind of makes sense. So that would be the independent source. A little bit more, so kind of an example, I guess, where an unlawful entry has given investigators knowledge of facts, X and Y and Z, but fact Z has also been learned by another lawful means. Fact Z can be said to be admissible because it was derived from an independent source. So just trying to kind of spell that out a little bit to make it easy to at least look at. And the case that gives us this application can be found in Murray versus United States. And then there's another kind of interesting one. I mean, and a lot of them are, but this one is definitely interesting. It's called the inevitable discovery rule. And the inevitable discovery rule provides that evidence that is seized as the result of an unconstitutional search is admissible where the government can prove by preponderance of the evidence that the evidence would have been inevitably discovered in the same condition in a lawful fashion. So again, kind of an interesting thing, right? I mean, when you kind of look at it in the context. So the case that we're looking at would be Nix versus Williams. So to give you just a little bit, the inevitable discovery rule was first fully articulated by this case, Nix versus Williams. And in this case, the defendant Williams was interrogated by an officer in violation of the defendant's Sixth Amendment right to counsel. And the defendant subsequently led the police to the location of a body of the 10-year-old victim. And you could tell this is a homicide case. And the police basically called off their 200-person search for the body of the victim following the defendant's promise to cooperate with police. So, I mean, do you think that with all of those searchers, and it was only actually a couple of blocks away, was the body, would they have found the body? Regardless of whether, I mean, if the person didn't tell them anything, would they have found it anyway? So here's kind of what the court basically observed. So one search team was only 2.5 miles from where the victim or where the suspect guided the law enforcement to. And it is clear that these search parties were approaching the actual location of the body. And we are satisfied, meaning the court, that the volunteer search teams would have resumed the search had the defendant not led the police to the body, and the body inevitably would have been found within an estimated 3 to 5 hours. So, there were a couple of justices that didn't quite go along with that, but the majority did. And that was kind of an example of the inevitable discovery rule, meaning they would have found it anyway. So even though there was a violation of the right to counsel, they still would have found it. At least that's what the court decided. And then finally, the last one in the line of exceptions would be impeachment, or what best way to say it would be calling into question. So evidence that is seized in an unlawful search may be used for the impeachment of a defendant who takes the stand. And there's no better case when you're talking about the O.J. Simpson case. And we'll get to the legal equation in a minute. Impeachment is defined as an opposing attorney's attack on a witness's credibility during cross-examination. And credibility means whether a witness is to be believed. So, for example, if a defendant charged with the possession of, let's say, child pornography states that he or she has never possessed child pornography, this statement may be challenged on cross-examination by introducing at trial child pornography that may have been unlawfully seized from that person's house. Does that kind of make sense? To impeach the testimony. So it's a very interesting concept. And why do you think there's a reason for the impeachment exception to the exclusionary rule? Because this one is a little bit different. Well, the U.S. Supreme Court here has reasoned that the jurors are entitled to hear all information that may assist them in deciding the case, and that a defendant should not be permitted to offer testimony that may be false or perjured without being challenged. So they may not allow the child pornography to be entered into evidence under other circumstances, but to impeach this person's testimony, it was allowed, and that's the impeachment exception. So, as always, we have some legal equations, and we talk about the exceptions to the exclusionary rule, etc. So, what do you think about that? And defendants may also be impeached by confessions that were unlawfully obtained by the police in violation of Miranda. And that would include things like inconsistent statements or even defense witnesses. So that's the impeachment type exception. Okay, so let's finish up talking about entrapment. And I have a video. We're not going to show it for lack of time, but typically entrapment deals with sting operations and the balance of catching the criminals and privacy. And if you have time, the New York Times article or video, if you will, on the child pornography sting, that's a very interesting type case. But let's go ahead and kind of jump into our entrapment discussion. So we have seen again that the Supreme Court held in the MAP case, that the exclusionary rule is required under the Fourth Amendment to enforce the prohibition on unreasonable search and seizure and to protect judicial integrity. And we also know that the exclusionary rule is a judge-made remedy that is not required by the Fourth Amendment. And we know now that the Supreme Court has created a number of exceptions to the exclusionary rule. And in most of these instances, the court has determined that the application of the exclusionary rule is likely to have little deterrent impact, and that the benefits of this modest amount of deterrence are outweighed by the costs of lost evidence and the possibility that guilty defendants will walk out of the courtroom without any type of criminal conviction. So the Supreme Court no longer justifies the exclusionary rule on the grounds that the use of unlawfully seized evidence at trial undermines judicial integrity. I mean, after all, while it's true that the introduction of illegally seized evidence places judges in the position of endorsing a violation of the Constitution, there is no equally important concern that judges are assisting guilty defendants when they exclude reliable evidence from trial. So, that's talking about, does the exclusionary rule deter unreasonable search and seizure? Well, now we're going to kind of shift, and we're going to talk a little bit about entrapment. So, American common law did not recognize the defense of entrapment. Okay? The fact that the government entrapped or induced, if you will, a defendant to commit a crime was basically irrelevant in evaluating a defendant's guilt or innocence. The development of the defense is traced to a U.S. Supreme Court's decision back in 1932 in a case called Sorrells versus United States. And in this Sorrells case, an undercover prohibition agent posing as somebody wanting to buy alcohol struck up a friendship with Sorrells and was able to basically overcome Sorrells' resistance and persuade him to find or locate some illegal alcohol. And Sorrells' conviction for illegally selling alcohol was later reversed by the U.S. Supreme Court. So, again, this case involves the conception and planning of an offense by an officer and his procurement of its commission by one who would not have actually done the crime except for through trickery or persuasion or fraud of the officer. And what this really means is this: it's the government's inducement of an otherwise innocent person to commit a crime. And that's kind of tough for us to understand, I guess. Because, I mean, think about it. Can you be induced to commit a crime? Again, the essence of entrapment is the government's ability or inducement of someone that is typically otherwise innocent and kind of induced to commit a crime. And decisions have clarified that the prohibition on entrapment extends to the activities of undercover agents and confidential informants and even private citizens acting under the direction of law enforcement personnel. And this defense has been raised in cases ranging from prostitution to the illegal sale of alcohol, cigarettes, firearms, narcotics, and even public corruption. So, again, can you be induced to commit a crime? Can you just be walking by and something is staged by law enforcement? An example would be if you've never watched the show Bait Car. And here's where they might leave a vehicle in an area and they'll leave the car keys in it. And they'll close the doors. The windows are rolled up, but the car is unlocked. And as they leave the vehicle there, pretty soon somebody gets their, they decide they're going to take the car, and they jump inside, they turn the key, they start it, and they drive off. Were they induced to take that vehicle? Or are they just criminals? And this is kind of the debate. So there are good reasons for the government to basically rely on undercover strategies, because this is typically where we get entrapment, are during these undercover things. So the first one would be certain crimes are very difficult to investigate and to prevent without using informants. And in addition to that, undercover techniques can result in a large number of arrests without the expenditure of a lot of different resources. And this includes things like posing as a buyer of stolen goods, or narcotics dealing, or money laundering, or anything else. And finally, individuals will be deterred from criminal activity by the threat of government involvement in that type of crime. So knowing that there are undercover officers, or there are these stings, might deter individuals. I mean, if you were going to find out a particular gang or biker group or something that was involved in criminal activity, you may have to send an undercover operator into the gang in order to see what's going on. That really is the only way to infiltrate. Does that make sense? So these are some arguments for. Well, there are also some criticisms, and we'll talk a little bit about that. A couple more as it relates to, let's do the against. So number one, the government may manufacture crime, again, by individuals who otherwise may not engage in criminal activity, meaning they'll set it up to where you might try to induce someone. Next, the government may lose respect by engaging in law breaking. Think about that. Next, informants who are employed by the government to infiltrate criminal organizations may be criminals whose own criminal or illicit activity is often overlooked in exchange for their help. So is that really fair, knowing that you're dealing with a criminal who's going to do something criminal, but they're going to report back to you something criminal on somebody else? Is that really a fair way of doing it? Next would be innocent individuals are approached in order to maybe test their moral virtue in determining whether they will engage in criminal activity. And is that really fair? So, example, I talked a little bit about the child pornography sting from the FBI at the very beginning of our discussion on entrapment. Take a look at that if you have a chance. And tell me, or think about whether or not you thought the way they went about it was that okay. Again, these are just some arguments, for, and against. So, setting people up, putting out a bait car, and maybe even locking the vehicle, but putting a purse on the front seat in a crowded area. I have a hard time sometimes understanding that, because if you break the window and you take the purse, it's not yours anyway. And again, entrapment is only a defense. It's not illegal, but it could be a defense to use to either get you, get the charge dropped, or etc. So could you actually entrap somebody? And a part of, again, of these undercover stings and stuff like that, or the laws even dealing with entrapment, are to balance the need of law enforcement to rely on undercover techniques against the interest of ensuring that innocent people are not pressured or maybe even tricked into getting involved in some type of illegal activity. And when we talk about entrapment, there are tests, and there are two competing tests that are found in the Sherman versus United States case. So in developing a legal test to regulate entrapment, judges and legislators both have attempted, again, to balance the need of law enforcement to rely on undercover techniques, because we need them, against the interest of ensuring that innocent people are not pressured or tricked into illegal activity. And as noted by the U.S. Supreme Court Justice Earl Warren in 1958, a line must be drawn between the trap for the unwary innocent and the trap for the unwary criminal. So unsuspecting innocent, unsuspecting criminal, and that's part of the Sherman versus United States case. And here, two competing legal tests for entrapment were nicely articulated by the U.S. Supreme Court in this case, United States versus Sherman. And it's subjective and objective. And without taking the time to kind of go through the whole case, we'll look at the two definitions of subjective. So the subjective test for entrapment focuses on the defendant, on the person, and asks whether the accused, that person, possessed the criminal intent or predisposition to commit the crime, or whether the government created the crime. So in other words, if not for the actions of the government, would that person have broken the law? And the majority of states and federal government, they use this particular test. So hopefully that kind of, makes sense. And, again, was the crime the product of creative activity of the government or the result of the defendant's own criminal design? And we see entrapment, the defense, used a lot of times when it comes to certain crimes. Drug dealing is one and prostitution is the other. So those are a couple of different types of crimes that you typically see this a lot. So the first step when you're talking about to determine whether the government induced the crime is whether or requires that the undercover agent or informant persuade or pressure the accused. A simple offer to sell or purchase drugs does not constitute inducement. Hey, you want to buy some drugs? That's pretty simple. Rather, inducement requires appeals to friendship. Come on, you're my best buddy. Compassion, promises of extraordinary economic gain or sexual favors, or even assistance. Hey, I'll help you in carrying out the crime. So that's a little bit more towards the inducement avenue. Now, the second step is the most important, and involves evaluating whether the defendant possessed that. Remember, I used the word predisposition, or the readiness to commit the crime with which they are being charged. And the law assumes that a defendant who is predisposed is ready and willing to engage in criminal conduct in absence of any of those inducements. So again, this all kind of falls under that Sherman case. So how do we establish this predisposition? Well, there's a couple of ways. So let's look at them. So one would be the character or reputation of the defendant, including any prior criminal arrests or convictions for that same type of crime. Next would be whether the government or the accused suggested the criminal activity. They brought it up. It wasn't the defendant. It was the undercover individual. Next would be whether the defendant was engaged in criminal activity for profit. Next would be whether the defendant was reluctant to commit the offense. Nah, I really don't want to. Oh, come on, man. Something like that. And then finally would be the attractiveness of the inducement. So that all falls, again, under the subjective test. And that is typically the one that most, both state and federal agencies use. On the other hand is the objective test. And the objective test for entrapment focuses on the conduct of the government rather than on the individual or the character of the individual. So, would it cause a normally law-abiding person to commit a crime? So again, that's the objective test. And I have an example that you can find on the internet. I may have even put it as one of the introductory areas in the chapter, but there's a sting operation where a young lady acts as, well, she's a young kid, but she acts like she's a lot younger, and basically gets into one of those chat rooms and arranges a meet with a sexual predator who's going to, basically have sex with somebody underage. And they basically set this person up. So, I mean, these are all different types of sting operations. Another one would be, the stash house. This is a really good sting video. So I've given you a couple examples to kind of look at. Another one would be, this is a really great one, where a wife decides that she wants to kill her husband, and she meets with an undercover officer. And she basically sets this up with this officer. So as you watch these, try to figure out whether it falls to the subjective or the objective. So, again, these are great videos for you to kind of help add some context. I even have a funny one where the San Bernardino Police Department are basically posing as, one of them is posing as a homeless person on the corner with a sign, and as people go by, he radios to officers around the area that people are talking on their cell phone. And again, it's kind of funny, but what do you think about that type of sting operation? Then finally, there's a very interesting book called The Terror Factor, meaning, and this book is written on the premise that our law enforcement agencies, specifically more the FBI, basically luring people in to become involved in terrorist activities, and then they end up arresting them before the activity actually takes place. So just a couple of different ways to look at things. And again, a lot of good videos to watch. And then here's, just to kind of finish up, are the legal equations when you talk about the subjective test, and then the objective test as well. Okay, so how do you invoke entrapment? And then we'll be done. Meaning, like, if you're going to use this as a defense, how do you invoke it? Well, invoking entrapment, it's an affirmative defense, which means that it needs to be raised by the defendant. And in jurisdictions that follow the subjective approach, the defendant is generally required to establish the fact of inducement by a government agent, after which the burden then shifts to the government to counter the defense by establishing the defendant's predisposition beyond a reasonable doubt. Now, in jurisdictions that follow or that have adopted the objective test, the burden of production of evidence and persuasion is placed on the defendant, which means the defendant has to prove all of the elements of entrapment, if you will. Okay, that was a lot of information that we covered, but I'm glad you hung in there. I hope that I was able to clear things up. Watch some of the videos if you have time, because I think they're actually pretty cool and they'll add some context to our discussion. So, with that being said, that's going to conclude Chapter 10, the lecture on Chapter 10, Part 2, the exclusionary rule and entrapment. And until next time.